Georgia executor duties, what you're required to do. Let's talk about that. If you have been named executor in Georgia, you may be wondering, what actually are you required to do? And what happens if something gets missed? Today, I am walking you through a clear step-by-step checklist of executor duties in Georgia so that you understand what is legally required, what is commonly overlooked, and where executors tend to feel the most overwhelmed. This role usually comes in a difficult season. It's not for the faint of heart, and the rules aren't always explained in plain English. So let's slow this down and walk through it together. My name is Tonya Bird. I'm part of the Bird Group at Keller Williams Realty Atlanta Partners, and I'm a husband and wife team where we help many executors get through the process of selling a home when they're going through this probate process. So let's dive in. What an executor is in Georgia. In Georgia, an executor is the person that is named in a will to carry out the wishes of the deceased. This isn't just an administrator role. As an executor, you have what's called fiduciary duty. A fiduciary duty means that you are legally required to act in the best interest of the estate, follow Georgia law, and put the interest of the beneficiaries ahead of your own interest. And sometimes ahead of the heir's interest, because an heir can be a beneficiary, but you can also have a beneficiary who's not an heir. So it is a position of trust, and it comes with legal responsibilities, which is why understanding your duties from the start is so important. So now let's dive into our checklist. First, you have to file a will with the probate court. This is the first step, is filing the original will with the probate court in the county where the deceased lived. This officially opens up probate and starts the legal process. And until this happens, nothing else can move forward. Then you have to petition the court for the letters of testamentary. The letters of testamentary give you the legal right and authority to act on behalf of the state. Without them, you cannot access the bank accounts, you cannot sell the real estate, you cannot distribute the assets. Even when everything is done correctly, this step can take several weeks, so timing really matters. Next up, notify the heirs, beneficiaries, and creditors. Georgia law requires that the beneficiaries are formally notified, as well as the heirs, and the creditors are given an opportunity to submit their claims. This often includes a published legal notice and sometimes mailing notifications out. So skipping or mishandling this step can create issues later and a potential liability for the executor. Inventory and safeguarding the estate assets. Executors are required to identify and protect all the estate assets, which may include real estate, banking and investment account, vehicles, and personal properties. This is especially time-consuming when you have your letters of testamentary in place, and now it's time to distribute the treasures that are in the house to everyone who is going to take on the treasures or whatever the will says, and then perhaps donate the rest. This is where a good real estate agent who specializes in probate can really be helpful for you, because they have people who have advisors, movers, those sort of people that can help you sort through that. So be sure to be looking for somebody who specializes in probate in your area so that you have that lifeline to help you through this. Managing the estate during probate. And while probate is open, the executor must maintain the property, pay ongoing expenses, including the mortgage. Because guess what? Probate does not stop foreclosure in the state of Georgia, so you got to pay any kind of mortgage that's going on so you don't get foreclosed upon. Keep clear records of all the activities. So you can see being an executor is an active role and not a waiting around role. Pay valid debts and expenses before any assets are distributed. The estate must pay approved creditor claims, final bills, and court costs. And paying the wrong expense or paying too early can expose the executor to personal liability. Handle real estate the right way. If the estate includes real estate, Georgia executors must confirm that they have the authority to sell. They must determine whether or not there's court approval that is required. And usually the will state whether or not that's waived and that you don't have to go in front of a court to get permission to sell. But if it's not waived, then you have to. And there's different ways of marketing a property that you can just sell outright because you have permission to, versus marketing one that is going to require the leave to sell petition, because that is a long, laborious process. So understanding that is key in this process. That's why you need, again, a good attorney and a good real estate agent who understands probate. Follow probate-specific sales date rules. This would particularly apply to if you had to go get permission to sell, because there's some timelines on that. And so this is one of the most common areas where executors accidentally just make mistakes. Distribute assets according to the will. Once the debts and expenses are satisfied, the assets are distributed exactly how the will states. It is not based on family pressure, verbal promises, personal opinions. Only what the will says and what Georgia law allows. And we're coming close to the final step. The final step is formally closing the estate with the probate court. This might include a final accounting, proof of distributions, and it may also require court approval. Until these steps are complete, your responsibility as an executor is not done. So let's dive in a little bit to the common mistakes I see executors make. Some of the common issues include acting before you get your letters of testamentary, before they're issued to you, mixing personal and state funds. You don't want to be mixing things up. If you have to use your own money, you document that so the estate can pay you back later, but you must document it. Selling the property without property authority. If you don't have property authority and that thing goes under contract, any closing attorney in the state of Georgia is going to say that you don't have the ability to close. So really understanding where you are in that process so that if you do go under contract and you do have to go get permission from the court, then the closing attorney and you and the agents and the buyer also is all on the same page. Underestimating timelines and legal requirements. Sometimes people think probate's done once you get your letters of administration, and it's really just started. So these mistakes are common, but they're also very avoidable with the right kind of roadmap. Who this role is really for. Most executors didn't ask for this role. They were chosen because they were trusted, responsible, and capable. But that doesn't mean they're expected to already understand the world of probate. If you're serving as an executor in Georgia and you want a clear, printable checklist of everything we just covered, I've created a Georgia Executor Probate Checklist, and you can just request it in the link below. You can fill out a short form, and the checklist will be sent directly over to you. It is designed to help you stay organized, reduce stress, and avoid common mistakes early on in the process. Thanks for watching, and if you're walking through probate right now and you don't have to navigate this alone, reach out. We can help you in the state of Georgia. Even if the house is not in our neck of the woods, we can connect you with a good real estate agent who understands probate so that you can navigate this process with the house with much more ease. We'll see you in the next video. Bye.